Hello, everybody. Thank you so much for joining us today for the webinar with the lovely Sonia. And I'm going to apologize, Sonia. I'm probably going to butcher your last name. Patenaude?
Patenaude.
Patenaude. Okay. So today we'll be going over small business, big ideas, protecting your intellectual property. Just a little bit of housekeeping. We will be recording. So if you do not wish to be part of this recording, please feel free to turn off your camera. Sonia has said that you're more than welcome to ask your questions during the presentation, but we do ask that you use the raise hand function to ask your question. If you don't feel comfortable doing so, please feel free to put your questions in the chat and I can relay them. Otherwise, a little bit about Sonia here. So she is a bilingual Canadian and US patent agent and has strategic and hands-on experience in procuring, developing, protecting, and licensing IP. Her experience spans private practice, government agencies, and in-house. Most recently at the Department of National Defense, Sonia managed the IP licensing sub-program focused on promoting continued industry advancements and improving the program's performance. Sonia also has in-house startup experience from HEXO operations, where she collaborated to build the organization's global IP strategy, developed IP best practices, and led IP education for management and stakeholders. She also spent over 10 years at the Natural Research Council of Canada, working as a patent agent and IP agreement expert. Sonia has a doctorate of philosophy in biochemistry. So we're going to love to hear from you, Sonia. And again, if anybody has any questions, please use that raise hand function or put it in the chat.
And I'll tell you right now, if you're asking questions about AI or software, that is not my wheelhouse. So just know that I will do my best and I will find the answers for you. So I'm glad that you could join us today. Happy to be talking to you. As Kylie noted, if you have any questions during my talk, please feel free to ask them. I like to keep a fairly informal talk. And to me, this is the way that we learn the most, is by listening to other people's questions and the answers to those. So the things that we're going to cover today, here we go. First, the disclaimer: this doesn't constitute legal advice to anyone specifically. It's just general information. If you do want specific advice, we do encourage you to seek out a service provider or legal counsel. So today what we're going to talk about, and we may not touch on all of the subjects. If we don't, that's okay. But what is intellectual property? We'll definitely talk about that. What is intellectual property? What does it constitute? How does it affect you? Where can you see it in your business? How do you protect IP? What IP strategy is, and why is IP important overall? I'll have also a few words about IPON programs and services, and describe to you how IPON can help in your IP journey. So first of all, what is IP? Well, I mean, a lot of you probably think, my business doesn't deal with a lot of things that are IP, but IP can be, it's across the board. It's so many things, and in so many ways sort of hidden sometimes. So if you think there are inventions, that's just typical. Everybody recognizes that that's IP. There are literary, scientific, artistic works. Think about all sorts of books and paintings, etc. Logos and names, we see those every day. Designs also constitute intellectual property. There's a slight difference between intellectual property and intellectual property rights. And the intellectual property rights, they offer the legal protection for the intellectual property. So think about patents, trademarks, industrial designs, etc. Then we'll talk about each of those in a little bit more detail. Intellectual property rights are exclusive, which means that the person who owns those rights can keep others from using their intellectual property. And they are time limited, which means there's a certain amount of time in which they are enforced. And we can go over those things as well. So let me just go to the next slide here. All right. So the types of IP rights, as I said, the typical ones that we see all the time, we're talking about patents, copyright, trademark, industrial design. You'll definitely recognize most of those things. Others that are not strictly in the strict sense types of IP rights, but they do constitute a fairly important part of intellectual property, are trade secrets and domain names. And we'll talk about those as well. So let's start with patents. What are patents? Patents protect inventions. Inventions can be anything, products, machines, processes, chemical compositions, all sorts of things like that. In order to be patentable, the invention has to be new, which means it can't be previously known. It has to be non-obvious, and that means to a person in that area, it can't be something that's obvious to try. And it has to be useful in the sense that it has to work. Improvements on existing technologies can be patented, and in fact, most patents constitute improvements on existing technologies. So improvement patents are very, very common. In Canada and most other countries, patent protection lasts for 20 years from the day that you file your patent application. So if you make an invention, you write a patent application, you file that with the patent office, you will have exclusive rights to that invention for 20 years. And some people would ask, well, what happens after 20 years? Well, after 20 years, then that becomes available to the public, which means anyone can use that invention. However, for the 20-year period, you do get an exclusivity on that particular piece of intellectual property. So what sorts of things can't be patented? Because that's almost as important as what can be patented. So the things that can't be patented are things like discoveries of nature, mathematical formulas, laws of nature, or purely mental operations. So you can't really patent something that is like a way of thinking about something. From the common law, so we have those statutory exceptions that's established by the law, but there are also other types of inventions or developments or technologies that are not patentable, and that's through jurisdiction and case law, and that is methods of medical treatment. So you can't, in Canada, you cannot patent a method of medical treatment. You can't patent something that relies only on professional skill. So a doctor, the ability to perform an operation. That's professional skill of a doctor. You can't patent that. Fine arts can't be patented, and higher life forms. So a mouse, a plant, a sheep, those things cannot be patented. You can obtain patents on many different technologies across many, many different fields. And in certain industries tend to be more prolific in patents than others. So here we see, this is a graph of the companies with the most issued patents from the United States Patent and Trademark Office. And if you look at the numbers there, you'll see, this is from 2023, you'll see that those numbers are 6,000 plus. So in 1 year, the companies that are obtaining the most patents at the USPTO have obtained 6,000 patents. But if you look at the types of companies that we're talking about, Samsung Electronics, IBM, Taiwan Semiconductors, a lot of the companies on this list are either in high tech or they're in electronics. So that area of technology is very, very prolific with respect to patents. So you can see that, it goes down, but still obtaining 1,300 patents in 1 year is quite large. So here's one example of a patent, and I'll go back and show you again so you can see the patent. So the front page of the patent, this is a very silly little thing. It's a spider catcher, and here's the video of it in action. Anything can be patented. It can be a very simple idea like this. It can be a very complicated idea like some sort of computer software or some sort of computer system. So you can see it's across the board. So you think, well, what's the advantage of patenting something like this? Well, you have a certain period of exclusivity on that. And lo and behold, this is available from places like Lee Valley Tools. So people are obtaining patents on this, and then they monetize those by licensing them out or producing product that is the technology that's patented and then making money off the sales. So you can see that there's a lot of potential here for patents of all kinds. Any questions about patents or inventions? No, I'll keep going. So the next one I want to talk about is copyright. A lot of people, and to be honest, copyright may be one of the most prolific types of intellectual property because people don't realize that they're creating things that are covered by copyright. So think about things like, your favorite novel or a piece of art, statue, painting, what have you. So you have a painting and or music. All of these things are covered in one way or another by copyright. So copyright protects things like literary, dramatic, artistic, and musical works. So books, articles, reports. For those of you who think, oh, well, my company doesn't create anything with copyright, any reports that you put out, copywriting exists in those reports. So you also have performances such as plays or shows or concerts, photos, paintings, sculptures, all covered by copyright. The interesting thing about copyright is that it exists upon creation. So you don't need to go out and obtain specific protection for copyright. As soon as you create the work, copyright exists in that work, whether you mark it or not. As I said, there's no requirement to register copyright. However, there are certain advantages when it comes, if you're going to litigate, there are definitely advantages if you register that copyright. Copyright is recognized essentially globally through multiple treaties. And so if something is copyrighted in Canada, let's say in the United States, they will recognize some measure of copyright in there. There are sort of two different sides of copyright. There's the commercial side, which is this IP right, and really it's what you make money off of. There's also the other side of copyright, which is called moral rights, and that gives the author a right of personality in their work. And this is something that can't be just given away by the author. Moral rights are the right of association, so the right of an author to be credited for their work. The right of integrity, which means that no one can change their work without permission of the author. And as I said, you can't assign those rights, you can't give them away. However, you can waive them. So let me give you an example and say, if I drew a picture, and so I own copyright in that picture, and I licensed it to you in order for you to reproduce that copyright. You're allowed to reproduce it, but you can't change anything in that picture. So if I chose the color blue for my picture and you decided, well, I really want to do it in red, you would have to ask my permission and I would have to waive my moral rights in order for you to do that. So changing colorization, cropping, things like overlaying text over top of an image, all of those things are moral rights. Other types of moral rights would be if someone has made a statue and someone wants to reproduce a picture of that statue. That would require the moral rights waiver from the author. So there are a lot of different things with respect to copyright to think about. The other thing to think about, and that may pertain to you, is photographs. Photographs have a lot of copyright. Obviously, they are copyrighted, so the photographer owns the copyright in their photographs. However, if you're taking photographs of a person and that person is recognizable in the photograph, it's important to realize that you will need permission from that person in order to reproduce that photograph. If you've taken a photograph of and you can recognize someone in it and you want to use it on your website, it's always best to obtain permission of that person because there are privacy rights and personality rights that are associated with the image of your image. So if someone wants to use your photo, they have to ask for your permission. Those are not strictly IP rights. However, they are so closely related and we see them involved so often with respect to photographs that it is worth a mention. So
all right, we do actually have a question, Sonia.
Okay, go ahead. Yes.
All right, Cindy, you've been asked to unmute yourself. There you go.
Hi there. Thank you. This is excellent so far. All of the copywriting and IP stuff really applies to what I'm doing. I have a podcast and all of my content is original.
Mhm.
So my question is, would it be advisable or useful to any degree to put all content copyright on the website and also on the platform where the content is made available?
Yeah, so on your website, it's actually a really great idea. And I was just about to bring that up. So thank you for introducing that. On your website, it's always a great idea to include a copyright notice at the very bottom. And if you go to a lot of the larger or, larger companies, you'll see at the very bottom of their website, almost every time there will be a copyright notice there. That's because anything you've written on your website belongs to you. It is your copyright, it is your material. And if someone wants to go and use that, they have to ask for your permission. So the same thing with recordings. Now, Cindy, recordings are, and I don't spend a lot of time on recordings because I'm not as familiar with that as with the, more like paper type of copyright. But recordings do have very specific requirements with respect to copyright and reproducing that, and people using clips of your podcast, etc. But all to say that yes, your podcast, your recordings, all of those things are subject to copyright. So I would definitely include the copyright notice at the bottom of your site. I don't know what platforms that you broadcast your podcast on, but probably there's a page for each episode. Probably a good idea to include a copyright notice there as well. And when it comes to copyright, just be very careful. Have a quick look at the contracts or the terms and conditions of any sites that you post your material or your work on, because they may have certain copyright restrictions, or they may impose certain copyright requirements on you. So you want to make sure that if you post your material on some streaming platform, that you retain the ownership of that copyright.
Yes, the platform that I'm on, it's Patreon, and it's created specifically for creators by a creator because of a lot of these issues. And I had stepped out of the creative world for about a decade. So is there a standard line that should be put, or can I just put all content copyright Cindy O'Neill in the year? Or
So
should it be a number of years?
Well, so it's that's a really good question as well. So typically the copyright notice will be the C, as you've all seen it right up here, and then the pink right there. You can see that that's the C. You'll have the year of publication, the year of first publication, and then you'll also have all rights reserved, and your name and all rights reserved, or your company's name, or whatever, whoever owns the copyright there. So that's what you would typically put. You can visit the Canadian Intellectual Property website. They do have a lot of resources with respect to copyright, and you can, it will give you a really good rundown of the high level, maybe what you need to know with respect to copyright. If you have any other questions, I really do recommend that you have you talk to maybe an IP lawyer or somebody who specializes in copyright. They may be able to just sort of run through some, best practices with you with respect to recordings.
That's splendid. Thank you so much.
Oh, you're welcome. Anything else, ladies?
We do actually have another one. With respect to intellectual property in a product, such as a training module, how can I guard against theft?
Well, as I said, it's always a really great idea to put the copyright notice while copyright exists. Even if you don't include that notice, including the notice just essentially puts people on notice that there is copyright in the materials. Guarding against theft is a really difficult issue. If it's available online, freely online, then there's a chance that it will get copied. The thing with all IP rights is they are exclusive to you, and you have the right to exclude others to use. But sort of like the flip side of that is you have to be aware and you have to police those rights. So if you have copyright in something, you have to kind of keep an eye out for anybody who may be copying them. And if you don't do that, that you have to have some diligence of your own. So you have to keep an eye out and look at the landscape and see if anybody is using or copying whatever you own. And if they are, then take action. So that demonstrates that you are, diligently protecting your rights. Usually people don't, generally, people don't want to be malicious about it. And if you inform them that they are using something that is owned by you, they will either stop, or it's an opportunity there to commercialize and monetize your intellectual property. And we'll get to that a little bit later, but it's an opportunity to license that to them. A lot of people will, if you want to use, in some cases it's free, they'll say, yeah, sure. We just want you to ask for permission. And because we want to know that you're using it in a way that we agree with. So usually you ask for permission, they may give you free permission. They may charge you one flat fee. It really depends. There's a lot of different models that are out there. I'm sure some of you will have seen the places where you go to buy the right to use a picture. You download the picture you want. The thing that I would be very careful about those places is that you want to ensure that they have the permission to use the photos that they are using, because that may or may not always be true. So all to say, you do have to police it on your own. The only way to really guard against theft and widespread theft is to make sure that as soon as you see someone using it, that you take action, because then it becomes more known that you are willing to approach people who are using your IP and tell them either stop or comply with these conditions. Does that answer the question? All right, great. Perfect.
And we got one more so far.
All right.
I build games. Is my copyright on game rules and card content text recognized elsewhere outside Canada? Copyright is formal.
Yes. So as I said, there is recognition of copyright. So if copyright exists in Canada, it will be recognized in most other countries as well. That is through various treaties that exist. And so quite often, if someone is infringing on your copyright in another country, you may have to go through, a few extra steps. But again, it is recognized outside Canada. So if, as you said, if you're creating games, and I don't know if those are like board games or, physical games, or if they're video games, but you'll see, I'm sure anybody who's doing this sort of thing, if you have a look, you'll see there's a copyright statement on all those things. And this is exactly the reason why, because it puts people on notice, and that way you can demonstrate that you are advising people that there's copyright, and that will help you enforce that copyright, particularly if you're looking at foreign entities. Anything else? See, copyright, there's a wealth of things, and everybody realizes it. So yeah, as I said earlier, everything that you put on your website, all the text that's there, it is subject to copyright. The thing about copyright though, and we get this question a lot regarding data. So, and this is more applicable to people who do things that have like, let's say you do an experiment and you have a table of data. People want to protect that data using copyright. Copyright protects the way that something is presented. So if you obtain copyright on your data, you're just obtaining copyright on a bunch of numbers. So somebody could come and reproduce that table in a different way, showing it in presenting in a different way, but that won't be infringing on the table that you presented, simply because it really is the appearance of what is on the page. There are certain things that can be, so translations can be protected by copyright of an original work. So for example, books get translated into a different language. That translation is not changing the substance of the book, and so it is considered copyright of the author. Well, it uses the copyright of the author. The translation itself will be copyrighted by the person who, the rights will be owned by the person who translates it, unless, of course, they are then assigned back to the author. So there are a lot of different things, little nuances with respect to copyright, but everybody, every single one of you will be creating copyright in your business. It's almost guaranteed. So maybe sometimes, realize those things and take a minute to ask a few questions about, does this apply to me and how can I protect that? So unless there's other questions about copyright, I'll move on to something else. All right. So trademarks. Trademarks are everywhere. They protect brands. So, and I think probably every single one of you has probably seen multiple trademarks already this morning, and it's only 11:30. If any of you have, a Starbucks cup on your desk or a Timmy's cup on your desk, you probably have multiple trademarks sitting right there. As I said, trademarks protect brands, and it protects elements that distinguish their goods and services from those of others. So these could be any of the things that are listed here and more. So words, designs, tastes, even textures, scents, sounds, all of these things, colors, 3D shapes, moving images, holograms, modes of packaging, all of these things can be trademarked. Trademark is also an interesting intellectual property right, because it can be registered, which is designated by the R in the circle, as I've shown here, or it can be unregistered, which is often indicated by the TM. So this is the unregistered rights are actually protected more like by common law. So, and they're usually geographically restricted. So while a registered trademark will be protected in an entire jurisdiction, say Canada, an unregistered trademark may really only be enforceable in a particular geographical area. So the GTA, for example, it all depends on where it's being used. Registration, again, does provide certain advantages in that it shows proof of ownership or proof of use by whoever registered it. The trademark will be presumed valid in the case of litigation, and it offers better enforcement options, particularly if you have to enforce against online presence. So compared to, unregistered trademark, there is no presumption of validity. Trademarks are good for 10 years. Well, in Canada, trademarks are valid for 10 years, but can be renewed indefinitely. So every 10 years, you can renew the trademark, and it can keep going as long as you keep renewing it and using it. So it's very important to continue using your trademark, even if it's registered and you stop using it. Someone could come in and say, well, they're just sitting on this and they're not using it. And that could result in your trademark being expunged. So if you have a very active trademark portfolio, it's a good idea to have a look at the older ones every so often to make sure that those are still in use. There are some different types of companies that will make more use of trademarks than patents. So we talked earlier about patents and how those can protect your IP. And here we're talking about trademarks. And let me give you an example of, a biotech company. So that's my wheelhouse. Biotech company, usually very heavily invested in patents. There are some trademarks, but usually very heavily invested in patents. Patents are usually the meat and potatoes there. However, in a different type of company, like if you own a restaurant, the chances are much lower that you will have a patent, but you'll rely a lot more on trademarks. And let me give you an example here. So who is familiar with McDonald's? McDonald's has a huge trademark portfolio. There are they have over the years registered 665 trademarks in Canada alone. And at this moment, they have 346 active trademarks. That is a lot. Their portfolio consists of all sorts of things. So it can consist of a word mark, which is basically a word. It's any use of that word. So McDonald's, as you can see here. You can also protect a phrase. So I'm loving it. Everybody's heard that. You can also protect a design. So the golden arches, everyone's seen this. This is trademark protected for McDonald's. And you can trademark sound. I don't know who reads music here, but ba-da-ba-ba-ba. Everybody's heard that on their commercials. this sound is trademarked. And when you go to the registration on the Canadian Intellectual Property website, there is a soundbite of it. So there is no doubt. So they show the musical representation, and they have the sound on the register. Interestingly, McDonald's has also trademarked ba-da-ba-ba-ba, which is how everybody sings it. So they've also trademarked that, which is kind of an amusing little side note. You can also trademark the combination of any of these things. So words and designs. So let me give you an example. So here we have McDonald's like this. We have other variations as well. So you can trademark variations of the same thing. So you can see that trademarks can really establish a brand with respect to this. So like I said, 346 active registrations for McDonald's, and they are very, very good at enforcing and making sure that whatever they are protecting is current. So as I said, over the years, they've registered 665 trademarks, which means right now they have over 300 that they previously registered that are no longer in use, and they've abandoned those. So it's a good thing to look at your portfolio ever so often going, you know what, I'm not using this anymore. I'm not going to incur the fees to maintain it. And so that goes off to the side. So trademarks
we do have another question here real quick.
Yeah, please go ahead.
I have a question regarding the variations. So with McDonald's, I mean, they're worldwide, so it's important for them, but the one where they have just the golden arches, and then the other where they have the golden arches with the name, is that something that you would recommend people do? So for myself, with this project and actually product, it's a product, I guess, more than anything. Do I need to trademark just an image and then the image with the words and without the words, or does it have to get that involved?
No, it does not. So you can trademark just the image, and if someone uses that image together with words or something else, you can make a case for that image still being recognizable as yours, right? They are incorporating your trademark into something else. They are still using your trademark. Yes, this is a case of, I mean, let's face it, McDonald's has I'm going to say it, pretty unlimited budget when it comes to trademarks. I'm sure they have a budget, but it's probably much larger than, you know, my budget, your budget, probably all of our yearly salaries put together, I'm guessing, just to maintain their trademarks. So they could rely simply on the golden arches, but they also, but because they have the means and the ability to also trademark it with the McDonald's logo, they want it to, you know, they want this particular thing to be trademarked. So if you look at it, you will see that I don't know if can you actually see my mouse screen? Okay. Yep. So you can see that this particular, with just the golden arches, you can recognize it, and you can recognize that golden arches within here too. Yeah. However, if you'll notice, this is their US logo. Yeah. This is their Canadian logo because of the little maple leaf. So McDonald's is targeting the ones that they are actually actively using. Now, like I said, they could rely just on the golden arches, but because they have the means, they've also chosen to trademark the other. So it's sort of, yeah, you sort of have to balance your pocketbook with what you're doing. Now, if they hadn't done this one and I was like, you know what, I'm just gonna take the golden arches and I'm gonna put Sonia's on top, I'm pretty sure that McDonald's would be knocking on my door in fairly short order.
Well, because they're large enough. Yeah, they're worldwide. But so right. In reference to a smaller company, a startup, trademarking in Canada is a different process than trademarking in the US, but you have a product. My product is online, it's worldwide. Would you advise trademarking in Canada and the US, or just kind of do it as you need to?
Well, Yeah, it's a little difficult when you're worldwide, you know, you're a small business, but you have a worldwide presence. It's a little bit more difficult. Usually, what I would say is typically, um, you target your biggest markets and, you know, biggest bang for your buck, essentially. So yeah, if you have a fairly large or a fairly, you know, important market in the US. Yeah, the Canada and the US are obviously two very big markets for us. The process is a bit different between Canada and the US, but not ridiculously so. There are various ways in which to, and I actually have a slide on this later. I don't know if we'll get to it, but there are different ways to go ahead obtain trademark protection. So there's this system called the Madrid system, which allows you to file one application and designate multiple countries. So you can, in effect, file in multiple countries. There is sort of like a threshold that if you, I think it's around 5 or 6 countries, it sort of like makes it financially more
Viable.
viable or advantageous if you do 5, 6 or more countries to use this Madrid system. It is like I've seen, I think it was like 8, 9, 10-ish countries, depending on the countries, obviously, that was around $15,000-16,000. So
Yeah.
you can see that it's still not inexpensive. However, it can be a good idea if you have an important presence in multiple countries.
Okay. I have,
Certainly a I would definitely, if you're concerned about trademark, I think my best advice, because I'm not a trademark agent, I do know about trademark. I know to a, you know, to a certain extent, but I would never advise anyone, you know, this is the best strategy. I would really recommend you go see a trademark agent and say, okay, this is my situation.
yeah.
What's the best strategy for me?
I have
It can be-
trademarked. You can do it on your own. I have done one trademark on my own for
Mhm.
Canada only. It was an interesting experience and actually a really good learning experience, but I just wanted to, because that was quite some time ago, I just wanted to check in, because things tend to change in that regard. So,
I mean, like I said, there are different systems available to you.
Yeah.
That doesn't mean that you can't go talk to an agent and see if they are able to give you some strategy or help you out trying to figure things out, and then you can maybe file some on your own. That's up to you.
right on. So
Yeah.
this is excellent. Hopefully you'll get to that Madrid part. That'll be really helpful for us.
All right. Any other questions, Kylie?
Nope, not right now.
All right, perfect. So now we're going to move on to industrial designs. Industrial designs are sort of like the opposite of patents. Patents will protect the function of something, how something works, or the mechanics of how it is put together and how the parts interact and things like that. However, industrial designs protect only the appearance of a product. So it can be shape, configuration, pattern, ornament, or a combination of those. So a good example is a chair. The ornate back on a chair, that could be protected by an industrial design, also called a design patent in the US, just in case you've heard that term as well. So it is really purely aesthetics. No function can be protected by an industrial design. It has to be new and appealing to the eye in order to be protectable. And in Canada, industrial design protection lasts for 15 years. So as I said, really purely aesthetics, no function whatsoever. And to be honest, there can be a whole litany of different things that can be protected by industrial design. Let me give you an example. The Apple Watch, the look of it is protected by design. The BlackBerry keyboard, the way it's laid out, that was protected by a design. So there are a lot of really different things that you can protect by industrial design that may not occur to you. One of the examples, and I pulled this from my own experience years and years ago, and I pulled some examples here for you. Becton Dickinson, probably most of you have heard of them. They're a global medical technology company, and they have many designs for their medical devices that are protected. For example, they'll have reagent plates. So the way that the wells are laid out the look of the plate, this is protected by the design. The appearance of a syringe barrel is protected by a design. A specimen collection tube and the look of the cap, not the function, just the look. And catheter assembly, this is what it looks like. So very, maybe not really things that jump to mind as being protectable by industrial design, and yet here it is, they've obtained industrial designs for those. So the next thing I want to talk about is trade secrets. So trade secrets are, again, really interesting because they are not, strictly speaking, an IP right. However, they do constitute intellectual property, and you'll get a feel for why once I tell you that, trade secrets really protect business information, and that information derives its value from its secrecy. So this can be, formulas or recipes. So you can, a formula for, I don't know, a recipe for chocolate chip cookies, or a recipe for a particular blend of oil. Things like that can constitute a trade secret. Compilations of information, so customer or supplier lists, those can be considered trade secret. Methods or processes can be trade secret. Inventions can be trade secret if they can't be reverse engineered. Well, there are a lot of things that have to do with trade secret, and undisclosed inventions can be trade secret. So you can have multiple different types of intellectual property that protect the same thing. So for example, if I have a composition that is, it's a composition that is a medication, that can be protected by patent. So typically what will happen is you'll protect sort of like the broader and less specific composition by a patent, because you don't want to tell people what exactly is in your composition, because that patent, everybody can see it. So what they'll do is they will protect the broader composition and say, well, we have anywhere from 2 to 10% of this of component A, and 5 to 25% of component B, and that sort of thing. Whereas your trade secret is the exact composition of your medication. So those types of things will tend to be trade secrets, or, something that cannot be reverse engineered. So methods and processes and other types of undisclosed inventions that by looking at it, no one could tell the difference. So let me give you an example of something that might not be reverse engineered. Is if you make a product and in your factory you use a specific process, first we put component A on, then component B, and then component C, and you're the only one that's figured out how to do this. However, by looking at the product, the customer can't tell, or no one can tell, how it was put together. That process can constitute a trade secret because no one will be able to figure it out. Because if someone can look at your product and figure it out, you've lost the secrecy. I hope that explains a little bit what trade secrets are. I didn't know everybody bandies around the name trade secrets. So there is no formal registration for trade secrets in Canada. They are protected by contract or tort, and usually the way that you that litigation ensues is over economic espionage or industrial espionage. Some jurisdictions, such as the US, have enacted legislations that do protect your trade secret. However, there are definitely conditions to that, or there are certain criteria to meet that ensure that you obtain that protection in those foreign jurisdictions. So amongst those, you should show a reasonable effort to protect that trade secret. So establish policies surrounding IP and confidential information. Train your employees about what is confidential, what is a trade secret, and how to treat those things. Keep an inventory of what trade secret you have, that is in fact a trade secret. Limit the disclosure of the trade secret. So not everybody at the company should know what the trade secret is. It should be limited to specific people who have a need to know. That need to know, there's a reason for that. You should also mark documents. with confidential or trade secret, things like that. So all of these things, it's important to demonstrate that you're doing all of these things in order to obtain that trade secret protection in those foreign jurisdictions. Now, usually people will trot out the Coke example for trade secrets. Everybody's heard this example, so I decided to pick something else. And I've picked WD-40. So WD-40 was developed in 1953 as protection against rust and corrosion. So a composition for protecting against rust and corrosion. The chemist sold the formula a few years later for about $10,000. The formula was never patented. It was bought and then placed in a bank vault and has been kept in a bank vault the entire time. WD-40, so in case you're wondering how valuable a trade secret can be, WD-40 is this company's only product. It is the only product that they make and sell. They make it and sell it in different, they sell it in different containers, et cetera, but WD-40 is their only product. The company that mixes the substance, they mix it in 3 different cities around the globe and then pass it on to their manufacturing partners in order to put together. So they maintained the trade secret for a very long time. Now, as I said earlier, a trade secret derives its value from its secrecy and usually shouldn't be reverse engineered. Now, anybody who has a scientific background, such as me, kind of goes, okay, what's the deal here? This is a composition of matter. With a mass spec, anybody should be able to figure out what's in here. And in fact, a lot of there's a lot of positions at this point that say, you know what, WD-40 is really, you could figure out what's in it by reverse engineering. However, the trade secret has kind of grown into legend sort of thing. So, you know, when you go to buy WD-40 at the store, do you call it any other thing than WD-40? And do you buy any other thing other than WD-40? That's how valuable their trade secret was. They've established just a huge foothold in that market and have kept it, despite the fact that their trade secret is probably really no longer much of a trade secret. So lots of value in trade secrets. For those of you, as I said earlier, I'm going to go back to the customer or the supplier list. So IPON maintains its roster of service providers as a trade secret because we've compiled this roster. We've done a lot of work to ensure that we have a roster of good service providers that we can refer our clients to, and we maintain that as a trade secret. So you can maintain the same thing. If you sell a product and you have a client list, that's not something that you would want your competitors to get their hands on. So that is maintained essentially as a trade secret. So maybe, you know, if you do have a list of clients, maybe you should think about putting some sort of protection around that in order to maintain that trade secret. So that's my spiel on trade secrets. The next bit that I'd like to talk about is domain names. So this is, again, not strictly an IP right in itself. However, it sort of borders on all of these areas. Domain names are basically the address of your website. We treat it as IP because most often it involves some sort of trademark probably or something of that nature. The domain name obviously can provide a competitive advantage, especially if it's recognizable when searching through Google or what have you. In Canada, everywhere, domain names are sold by domain registrars, and in Canada, that's the Canadian Internet Registration Authority, CIRA, for the .ca domains. Often, as I said, often your domain name can contain a trademark, so a company name or what have you, McDonald's, for example. And the owner of a trademark, a registered trademark, can file a trademark-based domain name dispute. So if you register a domain name that contains somebody else's business name and that business name is trademarked, they can file a domain name dispute and request that you no longer use that domain name. So when you're doing a search for your company name, or, you're doing you're like, oh, well, I'm going to get this domain because it's available. Maybe have a quick search as well to see if any companies have that registered trademark, because you might find yourself in a bad spot. Oh, and yes, a domain name can be registered as a trademark. So ipontario.ca, that could be registered trademark. Pero.ca, that could be a registered trademark. So in 2022, 1.1 billion domain names registered worldwide. That's how much there is with respect to that. And the most popular existing domain names are, listed here. Some of those you will absolutely recognize. Some of them, like Yandex and Baidu, those are foreign search engines. So like the Google of Russia, and I don't remember where the other one is. But interestingly, the most popular extension, as you can imagine, is .com, followed by .ca. So .ca is a fairly well sought after domain name. So something to think about. And then .org, obviously.
Sonia, sorry, just to interrupt real quick. I'm just going to give you the 10-minute warning. We can go 5 minutes over, but I do have another presentation in this room afterwards. So I'm just going to ask everybody to keep your questions now till the end.
Sure. So how is IP protected? This is where we're going to start really not getting into all of the slides that I have. So I'm just going to go through how IP is protected generally, and then skip maybe to the bit about IP Ontario. And if you have any questions, please feel free to contact me, or to contact Kylie, and she'll direct you to me. So how do we protect IP? Filing strategy and process differ on the type of IP being registered, the technological industry, and the size and stage of a company. So what you have to consider is, what type of IP protection are you looking for? Patents, trademarks, industrial designs, copyrights, all of these things have different processes. Where do you want protection? Because IP rights are just jurisdictional, so they are granted by country. What is the purpose of obtaining your IP protection? That will determine how it's great to file, but what's the purpose of it, so that you know what approach to take. Are you being very aggressive, or are you just trying to, eke out a little bit of a corner for yourself? Are you trying to prevent somebody else from using something? All of these things have different strategies involved with how you're going to protect your IP. When you're thinking about where you want to protect your IP, think about your market. So where are you selling? Where are you selling now? Where are you going to be selling in 5 or 10 years from now? Where are you manufacturing your products? Where will you be manufacturing your products? Where are your competitors located? Or potential infringers. So really think about those things as well when you're trying to figure out where you're going to. And of course, the dollars. So it is very easy to spend a whole lot of money protecting IP. But the reason we ask the first questions is so that you can really hone in on the best value for you. Where is the sweet spot? You want to protect your IP where there's a market for that IP. You want to protect it where there are IP rights available, and you want to protect it somewhere that will give you some sort of unique advantage over others. So where is that sweet spot of protecting your IP? And that is where you should probably concentrate your IP budget. If you have, all of a sudden you have greater resources, more budget, then you can start thinking about some of the, maybe a little around the sweet spot. So, maybe something a little bit broader, you protect in a few other jurisdictions, etc. Or maybe you start layering your IP rights. So I'm going to protect by patent and industrial design. All of these things play into how exactly we go about protecting your IP. I'm going to skip right over the timelines, and unfortunately, I'm sorry, I have to just skip over the Madrid system, but all to say, if you do want to talk about those things, any service provider will be able to help you out. IP strategy, again, IP strategy, when you're thinking about IP for your company, you want to start at the very beginning and work all the way through. And it, you know, you can establish IP strategy anytime, but if you do it at the beginning and you think about all the things you have to think about, you might avoid some problems down the road. So IP strategy should be covering all aspects of IP management, including the development of the IP, and should play into your innovation strategy or your creative strategy. You should think about protection, maintaining, and eventually making money off of your IP. So monetization and commercialization. You want to make sure that your IP, you're managing your IP in a way that it will promote the success of your business and it works with your business plan to get you where you want to go. So you can, Kylie, I think I'll forward the slides to you, but you can have a quick look and see through these. There's a whole bunch of questions here to think about when you're thinking of what sort of thing, you know, how do I establish an IP strategy? How do I build that? How do I go through this and make sense of this in the end? And if you can go through and answer questions such as these and bring them to an IP service provider, it will definitely give them a good start to try to build you something that can help you. So I'm just going to flip through all of these. Why is it important to have IP? Well, IP can protect your business assets. It can help transform those into commercial assets that make you money. It will enhance the value of your company and will attract more funding and possibly more partners. It can definitely establish a foothold in the market, and it can discourage potential infringers. So all of these things very important. And here are some, you know, some very basic numbers that can help you see what the difference is between companies with IP and companies without, you know, with patents and without patents. So IP protection versus not protection. You can see that there are definite advantages. IPON can help you out. Our entire raison d'etre is to provide funding to small and medium enterprise in Ontario to allow them to protect their IP, establish patent strategy, etc. So we offer a variety of services that can be foundational education, advanced education. We do have free public events and we have free online resources. For our clients, we offer IP benchmarking, so evaluation of the IP awareness and health of your company. IP intelligence, we have landscape reports and landscape analysis that may help you identify white space or competitors or trends and things like that. We offer one-on-one mentoring to our clients, so they can have access to a mentor that with lived experience in that, hopefully in that same industry and in the area in which they want some help in order to help them kind of figure out how to go about establishing IP strategy or, for example, branding or clinical trials or things like that. So we match our clients with mentorship. We also, as I said, offer IP funding for protecting your IP. So right now we're at the tail end of our initial scale up, and we'll be starting a new program in April. If you have any questions, please visit our website at ipontario.ca. You can have a look at the apply, under the apply category. There'll be the eligibility criteria where we have certain priority sectors, priority technology sectors that we are currently looking at, but those may be expanding in the near future. So if you apply now, you'll have time to be accepted, do the education component and the benchmarking component, both of which are required in order to obtain funding. And then after that, once we have funding calls, you will have access to certain pot of money, and then you can use those with service providers in order to obtain trademarks or patents or set in place an IP strategy. We offer reimbursement of costs to 80% for most IP related services. There are certain things that we don't cover, and those can all be discussed with you if you are interested. So just to close, I will mention that there are other organisms that provide funding. Innovation Asset Collective, IP Assist, and Elevate IP all provide different types of funding under different circumstances. So if you can't receive any funds from IPON because you're not eligible or in a different area of technology, then I would encourage you to also seek funding there, and wish you good luck. So there we go. No more questions. No more talking from me, only questions from you. Kylie, I think there's a bunch of things there in the chat. I'm not really sure what's
That
going
was
on.
pretty much me telling everybody, if you have any questions, if you want to be connected with you yourself, Sonia, if you would like a copy of the recording, and once you as well get me that slide deck, Sonia, you can email me at communications@pero.ca, and I will send you a link to the recording, the slide deck, all that good stuff.
Okay. Any other questions before we go?
You're excellent at what you do, Sonia. Thank you so much.
Oh, thank you.
That's exactly what I was going to say too. I raised my hand just to say that this was excellent and very informative, and thank you so much.
Oh, you're very welcome. I'm glad that all of you got something out of it. Hopefully, even if it's just to figure out what exactly is IP, if that's all you got out of it, then that's wonderful. And any IP awareness, probably the next time you come across it, you go, oh, you know what? I think there's a question to be asked here, and knowing when to ask the questions is really probably the biggest battle. So I really do wish all of you good luck in your IP journey, and hopefully I will cross some of you on our application process so that we can get some funding to your small business.
All right, thank you so much, Sonia, again for coming today to this wonderful presentation. Again, if you would like a copy of the recording of today's presentation, and again, once Sonia gets me the slide deck, I can share with those who ask. Please send me an email at communications@pero.ca, and I'm more than happy to share those with you. Otherwise, thanks so much, everybody, for joining us today. Have a great rest of your day. Bye-bye.
Bye.